Can I ask you about the first issue, the question of whether it's jurisdictional? I read our cases to create a fundamental divide between statutes that speak to the court's authority and statutes that impose commands on litigants or prohibitions on litigants. And this statute, at least on its face, speaks to the court's power to review. So why isn't that enough in this particular case?
Your Honor, I certainly think that's a relevant factor, but by no stretch do I think that's a sufficient factor. And let me offer some other examples. So in the context of Section 1252 itself, we cite to provision B2 in the briefs, where B2 says, quote, "The Court of Appeals shall review the proceeding on typewritten briefs." That's mandatory. It uses the word shall. It's a direction at the court. It's saying what the court shall do, and it's in the context of review.
This says may review only if, not if, only if. And this provision in 96 carries forward a prior version of this language that this court itself had referred to as jurisdictional. And so I guess still put aside the example you gave, why shouldn't the divide, and we referred in Fort Bend to the divide being does the provision speak to a court's authority as opposed to a party's procedural obligations? And this seems to speak to the court's authority because it says a court may review only if.
Well, in a few ways, a few answers, Your Honor. First, there are additional examples. Habeas in Section 2254B speaks to the court's authority. The First Step Act speaks to court's authority, but those have been found to be non-jurisdictional. I can explain that. But on the recodification point, to Your Honor, there are two pretty essential points. First, I don't think it's fair to read Stone as having said the exhaustion principle was jurisdictional. Certainly, there's no express holding that would trigger a recodification provision or doctrine. But second, beyond that, in 1996, Congress did change the language. Now, it didn't change the language enormously, but it changed the language. And I think this is important because in 1996, in ARERA, as we point out, in 12 other places, when Congress wanted to strip—
But I guess, I'm sorry to interrupt, but does this language speak to the court's authority?
It directs actions courts take during review in the same way that B2 does. I don't think, though, that necessarily means it is a limitation on the power of the court. At least that's not the only plausible understanding of the statute as a limitation on the power of the court.
Do you think Congress could make an exhaustion requirement jurisdictional without using the word jurisdiction?
I think it would be exceedingly difficult for the court to do so because—
And why then do we have a special magic words requirement just for exhaustion requirements and not just follow the usual Fort Bend divide?
So, Your Honor, I'm not suggesting there's some special magic words, but I think there are several factors that counsel here. One is the point of what Congress did in all the surrounding provisions. It had in this statute a special language when it wanted to, so I do think the magic words applies a bit differently in the context of this particular statute. But with exhaustion, especially in the context where it is an agency that is establishing the rules of exhaustion, it would be passing strange in our view that an agency has delegated the authority to establish rules that themselves then have jurisdictional character that limit the subject matter jurisdiction of federal courts. We think if that's what Congress intended, it would need to say that expressly.